njengokumele wakho achaza okwamanje uyasho ukuthi kunesikhalo okhala ngaso ukuthi umshushiso ophethe icala lakho bekachazile ngevikendlulile ukuthi yena uzabe ase-high court kodwa uma babhekisisa kahle iy'ncwadi zale case behambela khona e-high court akunalayo igama lakhe livela khona into yenza ukuthi babuze ukuthi kahle kahle badonse leli cala ngabomu noma ngenhloso na benzele ukuthi bajezise wena uyasho phambi kwenkantolo ukuthi yiyo into engathi iyaphazamisa leyo ukuthi abazwisisi ukuthi kahle kahle bahloseni into ayenzile ivile epheliwe.
Your response, Advocate Sekonyan.
Thank you, Your Worship. These are very, very, very serious allegations against my character as a prosecutor. Your Worship, I was appearing in the matter of State versus Rasilukune plus one other with case number CC 41 of 2024 for Honorable Judge Makamu. This is a matter which started in 2023 and it's ongoing. Your Worship, the defense is saying that they are getting instructions from their clients that he got information, and I'm saying he must fire those informants. He must fire them because they are ill-informed. They are very ill-informed. And I took it upon myself after leaving your office to call the office of Judge Makamu, and I spoke to Ms. Lebo Hangmoyeti, who is Judge Makamu's registrar, to ask her to prepare a record of the proceedings. And I request this matter to stand down until those records are available, because this is a fight on my character. And I cannot proceed with this matter in light of the fact that I'm being alleged to be a liar who lied to this court to say I'm going to court, whereas I was not going to court. My learned friends did not do their research properly, Your Worship, because this matter was postponed in conjunction with State versus Modolo, which is a matter before Judge Makamu, who did not proceed. And these two matters were put, or they were postponed on the same date in case Modolo does not proceed. Modolo did not proceed, and I proceeded with the matter from Tuesday up until Friday. And I request this matter to stand down. I have called the Secretary of Judge Makamu for her to check when these records will be available, because the accused must be satisfied that it's a prosecutor with integrity who's appearing before this court. And as of now, I am a prosecutor who does not have any integrity, and I have to clear my name because the defense is alleging that I was not in court just because I'm not on the roll. Had they bothered to phone me and ask me, I could have told them which matter it is. They could have verified with the registrar of the High Court, as the court pleases.
Right, so you are saying that you want the matter to stand down so that you can obtain those records first before we can proceed with this proceedings today?
Yes, Your Worship, because the accused is not satisfied clearly because I lied to this court. And Your Worship, what does the court say about my character as a prosecutor and my integrity? If I could lie about being absent for 4 days just to avoid this matter proceeding, it says a lot about my character as a prosecutor, and I cannot just let that slide. I fail to understand how the advocate can say it's neither here nor there. This is a very serious allegation that they're bringing, and he can't say it's neither here nor there. This is very serious. Thank you.
Your response on the issue of standing the matter down until we obtain the records?
Your Worship,
bearing in mind, Advocate, that is going to cause a further delay. Remember, my concern here, as I sit here, is to make sure that this matter proceeds as speedily and fairly as possible towards the client as well.
Indeed, Your Worship, I don't think whatever my learned friend's information that he wants to obtain will impede on this matter from proceeding, Your Worship. As I've indicated, that the issue is neither here nor there. The issue that is before your leadership is whether Mr. Nkosi is entitled to be released on bail, or the interest of justice permits that he be released on bail. And such information as the office of the court can provide to the court at a later stage, Your Worship. But it was just the observation of Mr. Nkosi, Your Worship.
Right, I will make a ruling on this. So far, Advocate Sokonyana, these are allegations, and you also have your side of the story. As I sit here, this court is entrusted with these proceedings to make sure that we proceed as speedily as possible. I am not going to cast a stone and say that you are guilty of any misconduct or any misrepresentation. You have your side of your story. They also have those allegations. For now, I'm not going to halt these proceedings and wait for anything else. You can get those records later in the day. But for now, as far as I'm concerned, we haven't done anything wrong. It is the court's duty, and the court will proceed to manage this matter in a manner that safeguards the accused's fair trial rights and minimize any further delays. And for that, let's proceed.
As a court business.
Right, when we left off last week on Monday, the defense was still busy with addressing the court. The applicants' heads of argument were handed up, and Advocate Dali was still busy with addressing the rest of the address on merits of the bail application.
As a court business.
Right, let's give Ms. Kosana a chance to interpret the proceedings as well. We mustn't leave her behind because your client said he speaks Isizu.
As a court business.
Njengoba umshushisi bekathelile ukuthi inkantolo ime kancane ukuze naye akwazi ukuthola ama-recordings abawacelile khona e-high court ukuveza ukuthi yena umuntu othembakalayo, njengoba wena kwezile ukuthi kukhona ukungabazi onakho ngeqiniso lakhe, uyasho ukuthi ucela inkantolo ime kancane akwazi ukwathola lawo ngama-recordings. Kodwa inkantolo iyasho ukuthi asikho isidingo sokwenza njalo, bazoqhubeka ukuze bangamoshi isikhathi sakho, njengoba nawe unalo ilungelo lokuthi icala leli acede ngalo ngokusheshisa, njengoba unalo ilungelo lokuthi benze njalo. Bayasho ukuthi isidingo sokuthi babe kancane ngaleli cala asikho, bangathubeka nesicelo sakho sebeli.
Yes, you can carry on with your address and merits of the bail application.
Thank you, Your Worship. I would like to refer Your Worship to paragraph 7 of my heads of arguments in the matter of State versus Atchison, where Your Worship as well, we have held on previously that the bail application should not be the form of punishment to the applicant, because every applicant that becomes before Your Worship is presumed to be innocent, and the duty is just to weigh up whether it will be in the interest of justice that Mr. Nkosi be released on bail. But you should not treat this matter as if you are a trial court, but as a bail court where the guilty or the innocence of the accused is neither here nor there, Your Worship. However, what we have to look at is whether when you release him, that will likely prejudice the ends of justice. And it is my submission that, having regard to the evidence that has been given by the accused and given by the state, there is no indication that if Your Worship releases the accused on bail, that will prejudice the ends of justice. And I'm saying this for the following reasons, Your Worship. The state is saying that in their allegations that one firearm was found underneath the mattress of the minor child, and the other firearm was found in the motor vehicle. And because of that, he is endangering the lives of his wife and the minor child that he lives with in his house. However, you should consider that these firearms that the state alleges that were not kept in the safe and that the safe was not mounted, those firearms have been taken by the state, Your Worship. And one cannot say that because of the allegation that the applicant will endanger the life of his minor child and his wife because he lives with them in the house. And in paragraph 9 of my heads of arguments, I refer this court to the case of State versus Branco, which emphasizes the importance of section 35(1) of the Constitution, that this right is a precious right, and the court, in considering the application of Mr. Nkosi, it should consider that his freedom is important, and it's only the trial court will have to determine whether he is guilty or not guilty, and that his freedom should be taken away. And it is not for this court to impose some sort of punishment by denying Mr. Nkosi to be released on bail pending the hearing of his matter. And Your Worship, you are dealing with these matters on daily basis. Also, the Constitutional Court in the matter of State versus Dlamini also indicates to this court what is the objective of the bail application. I go to this judgment, Your Worship, in paragraph 11 of my heads of argument, that what you should consider is whether it is in the interest of justice that he be released on bail or not. And it is my instruction, it is my submission, Your Worship, that considering the circumstances of this case, that Mr. Nkosi, it is in the interest of justice that Mr. Nkosi be released on bail. Now, Your Worship, you will note that in paragraph 5 of my heads of arguments, I refer you to this matter of State versus Zuma. And the purpose of referring, Your Worship, in that matter, Your Worship, is to persuade this court, Your Worship, not to have regard to the halabano that is happening outside, that they want to connect the arrest of Mr. Nkosi to what had occurred at Madlanga Commission. These charges, Your Worship, they have got nothing to do with what transpired at Madlanga Commission, even though that the state in the bail affidavit in opposing these applications, it seems as if they want to draw a comparison to what happened at Madlanga Commission and what the Mr. Nkosi is charged with before this court, Your Worship. And it is for that reason, Your Worship, that I referred you to that matter of State versus Zuma, because I don't want this court to concentrate on the noise that is happening outside and forget to apply the principles that this court has to apply as provided in section 60, subsection 4 of the Constitution. And now, Your Worship, I will take you through to the reasons why the state is opposing this bail application. And in doing so, Your Worship, I will take you through to what is provided in section 60, subsection 4 of the Constitution. I will start at page 19, Your Worship, of the affidavit in support of the opposition of this bail application, which start at paragraph 11 of that affidavit.
Yes, carry on.
Thank you, Your Worship. The investigating officer submit that he finds it disturbing that the applicant was found in possession of these dockets and these exhibits, and that the applicant stole these dockets as they from the stations where they belong, and the applicant's commander issued a statement filed as per A17 in the docket, stating that she is not aware of the dockets mentioned above. the court will remember that in the evidence of the state, they are saying that the station commander of Mr. Nkosi does not remember signing for these dockets. There is no statement or evidence that has been put forward before this court that these dockets were stolen from the police stations. And in their allegation stating that these dockets were stolen in the police station, it contradicts what is stated in this affidavit in opposition of this bill application. Because on the same breath, Your Worship, they are saying that Mr. Nkosi went to Musina and requested that docket to be given to him, and he used his office as the national office in order to do that. And then how do you now come to the conclusion that those dockets were stolen, but at the same time you are saying that Mr. Nkosi went directly to the police station and demanded those dockets to be given to him? And this corroborates what Mr. Nkosi says in his affidavit in support of the bill application, that these dockets, the President of South Africa, the National Commissioner, and the Deputy National Commissioner requested that these dockets be centralized in the national office so that they can be dealt with. These dockets are the dockets that involves cash in transit and the violent crimes. And in his affidavit in support of the bill application, he indicates that this direction comes directly from the National Commissioner, the President of South Africa, and also the Deputy National Commissioner. And there is no evidence from the state that disputes this averment that has been made by the applicant, that this instruction is coming directly from the office of the President and the National Commissioner, that he should deal with these dockets. And this notion that Mr. Nkosi is dealing with these dockets that have been stolen in various police stations, Your Worship, is not supported by evidence. And even if, Your Worship, you were to find that this averment is true, which is denied, your purpose, Your Worship, is to look at the evidence that has been presented to you and decide whether it will be in the interest of justice that Mr. Nkosi be released on bail or not. If Your Worship goes to page 26 of this affidavit by the state, the next bullet point that appears there, the state alleges that the applicant is not suitable candidate to be afforded bail, as he can use his influence in higher offices to get anything that he requires. It will not be in the best interest of justice to release him on bail. He may easily interfere with investigations or intimidate witnesses. Your Worship, there is a bold statement that has been made by the state that if my client is released on bail, he might contact the higher office and he will have influence in these proceedings. There is no evidence, Your Worship, that since his arrest, he had tried to influence this matter to go in his favor. And there is no evidence, as I've indicated, that this is his first arrest, Your Worship, that in the past he had tried to influence the investigations that are against him, and in order for this court to find that he has got a propensity to influence the investigations against him, Your Worship. The state only says that he will influence the higher offices, and the court should remember that Mr. Nkosi now, he does not have access to any police information, as he was suspended on the 28th of last month, Your Worship. And this averment that he will influence the higher office and try to get this information or influence witnesses is not substantiated by any evidence, Your Worship. And as such, Your Worship, this court should not consider that Mr. Nkosi will influence the witnesses. As I've indicated last week on Monday, Your Worship, the witnesses in this case, Your Worship, are mostly the members of this national task team. Those are the people who will testify that the safe was not mounted. They will be the people that will testify that the firearm was found in the motor vehicle or under the mattress, Your Worship. And it is my respectful view, Your Worship, that there is no evidence that Mr. Nkosi will influence the members of the National Task Force, Your Worship, who will be giving the evidence against him in the main trial. In paragraph 12, Your Worship, this is paragraph 12.1 and 12.2 of the affidavit opposing the bail. This is where I was going, Your Worship, when I referred you to the matter of State versus Zuma. The state now is saying that Mr. Nkosi has association with the organized crime, and that is the reason why he should not be given bail. You are aware of the charges that Mr. Nkosi is facing, Your Worship. The charges that he is facing relate to the position, to failure to mount the safe, and the possession of the ammunition that he was not supposed to be in possession of. They do not relate to drug trafficking, which is stated in paragraph 12.2, Your Worship, which comes from Madlanga Commission, Your Worship. And he has not been charged with drug trafficking, Your Worship. However, what the state wants to make, Your Worship, wants to make noise about what is happening outside this court in order to draw comparison with whatever that is happening in this court, whereas the charges are completely different, Your Worship, and he has not been charged with what is averred in this paragraph 12.1 and also paragraph 12.2 in this application for opposing the bail of Mr. Nkosi. It is my submission, Your Worship, that he is not being charged with the association with the drug cartel or with the charges, with the syndicates that the state is alleging in paragraph 12.2. Now, the state in paragraph 13.1 says that Mr. Nkosi in Madlanga Commission requested that he should testify in camera. That is paragraph 13, Your Worship, at page 20. And these allegations go to the next page at page 21, Your Worship. And they say that this is an indication that his life, there's likelihood that his life was in danger, and that is one of the reasons that he should not be released on bail. However, Your Worship, you are confined, you are a creature of statute, Your Worship. We are confined by what is contained or what is codified in section 60, subsection 4A to E. There is nothing in section 64A to E that says if the accused's life is in danger, because he should not be released on bail, Your Worship. And this, in terms of section 60, subsection 4, or those factors that you have to consider there. And also in this regard, Your Worship, it is my instruction that Mr. Nkosi testified in Madlanga Commission after his name was revealed. And he stayed in his house, and his life was not in danger. He was able to go about his own business even after his name was revealed. And the allegation that his life is in danger, and for that reason, he should not be released on bail, Your Worship, it is not supported by any evidence, Your Worship, because after his identity was revealed, he was staying in his house, and his life was in no way being endangered. And there's no evidence that has been brought by the state that after his identity was revealed, there was an attempt on his life, Your Worship. And it is my submission, Your Worship, that it will not be in the interest of justice that he be kept in custody because of the mere fact that the state is alleging that his life will be in danger if he's released on bail. Now, Your Worship, I want us to deal with what appears in page 21 at paragraph 14, 14.1 to 14.2 of the bail affidavit opposing the bail. The state is saying that what they found during their search, and they say that this demonstrates recklessness on the part of the accused, and they are saying that if he's released on bail, there are concerns of public safety within the household of Nkosi family, Your Worship. As I've indicated, Your Worship, this is not merited. The court is well aware that if you are charged of contravening the Firearms Control Act, it is the duty of the police to confiscate the firearms. And these 7 firearms that are licensed, by the way, Your Worship, are in custody of the police. And there's no merit now that if Mr. Nkosi is released on bail, he will endanger the life of his kid and also of his wife, Your Worship. And as I've indicated, Your Worship, that Mr. Nkosi denies these allegations, and it is for that reason that this is denied, Your Worship. Now, Your Worship, let's go to paragraph 15, 15.1 and 15.2 of the reasons why they are opposing bail. I will start deal, Your Worship, with the issue of the ammunition. They are saying that he was found in possession of the unlawful ammunition which was issued by the state. At the time when they found it, he did not have a permit to possess such an ammunition. I want the court to come with me in this chain and what the state has alleged. They allege that he was suspended on the 28th of March 2026, Your Worship. And he was arrested 4 days after his suspension. And in Exhibit B, Your Worship, that the state has tendered before this court is Annexure TM1, the statement by Rosie, which is Annexure TM2, Your Worship. In that statement, Rosie indicates what she received from Mr. Nkosi, Your Worship. And what is important, Your Worship, is that at the time when she took whatever that was in possession of Mr. Nkosi, Mr. Nkosi's access card to the national office was taken away. And in his affidavit, to be released on bail, Mr. Nkosi, alleges that because he was informed when he was suspended in terms of the internal disciplinary hearing, he is not supposed to go to the office. He could not hand back whatever that was in his possession, which was in his house, Your Worship. And he spoke with his attorneys, and the attorneys advised that he should wait for the police to indicate what should happen with what is in his possession, Your Worship. That is contained in the affidavit of Mr. Nkosi. And there is no evidence to counter that, my Your Worship. And what was in his possession, Your Worship, that belongs to the state? It was the ammunition that was issued to him by the state, lawfully so. And these dockets, Your Worship, that were found in his house, Your Worship, because he was working on them. And now, Your Worship, the question that one has to ask itself, whether if I may make just an example, your assistant, if she is suspended today and then she is charged on Friday and she left with a pen that belongs to the Department of Justice, will you arrest her for possession of unlicensed pen? The person who's working with this pen on a daily basis, and he was suspended on Monday, and now he's charged on Friday. And during his suspension, he was told that he must not come to the national office, and there was no way that he could have brought the pens that were in her house at the time of his arrest. Will you punish such a person for that, Your Worship, who was arrested 4 days after his suspension? And it is my submission, Your Worship, that the regulations of the state that are the applicant referred to in his founding affidavit in support of this appeal application do not speak to that. And the reason why Mr. Nkosi was in possession of this ammunition that was issued by the state and also these dockets is because at the time of his suspension and when the access card was taken from him, he was not in possession of such documentation, and there's no way that he could have handled such documentation, Your Worship. And it is for that reason, Your Worship, that I state that this charge and also this reason for opposition, Your Worship, is not merited, Your Worship. And I must remind you, Your Worship, that the court that will ventilate these issues will be the trial court, Your Worship. At the trial court, these issues will be ventilated, Your Worship. However, what you have to consider, Your Worship, is to whether Mr. Nkosi has discharged the onus that lies on him, that it is in the interest of justice that he be released on bail, Your Worship. And we are talking about here, Your Worship, about the person that has been arrested for the first time, Your Worship, and he has already alluded to his personal circumstances, and it is my submission, Your Worship, that he has discharged the honors that rest on him. In page 22 of the affidavit, Your Worship, paragraph 16.1, the state relies on section 60, subsection 4A, of the Criminal Procedure Act, and they say on the side endangerment of public safety. They say that my client has demonstrated the capabilities of shielding the dangerous criminals who are involved in the city, in the CITs and robberies with aggravating circumstances involving the use of dangerous weapons. The applicant failed to arrest and charge the suspects who were clearly linked to the hijackings and are still not charged and posing serious danger to the safety of the public. Your Worship, Mr. Nkosi has explained in his affidavit the reason why he was in possession of these targets. And the state also in the affidavit has made it clear that Mr. Nkosi went directly to the police station, which is situated in Musina, and requested that this target be given to him as he was working on it. That's what the state is saying. And they are saying that he is shielding the dangerous criminals, and this will endanger the safety of the public. Your Worship, I submit there is no evidence that if Mr. Nkosi is released on bail, will endanger, there's a likelihood that he will endanger the safety of the public, or he will commit a Schedule 1 offense, Your Worship. There is no such evidence. And the allegations are pertaining to this, Your Worship, will be dealt with, Your Worship, by the trial court, Your Worship. And they are saying that because there was an amount of 385,000 and the amount of 52,000 that was found in his possession in April 2006, he will commit a Schedule 1 offense, Your Worship. I don't know on what basis will you say that you will commit a Schedule 1 offense because you have found in possession of money. What makes them to make a decision or be of the opinion that because he was found in possession of the money, he will commit a Schedule 1 offense? This gentleman that is before this court, Your Worship, has been employed by the police since 2008. And there's no evidence that in his course of employment he committed any offense or he interfered with any of the investigations within the police, Your Worship. And you must not lose sight of what the charges pertains to, Your Worship. The charges pertain to what is before Your Worship. And as I've indicated, that the police officials are the one who will be testifying in this matter against him. And there is no evidence that if he is released on bail, he will endanger the life of the police that were involved in his arrest, Your Worship. Your Worship, in paragraph 16.2, they say that the issue of the length of the sentence that may be imposed by the court will make him not to stand his trial, Your Worship. There is a case that has been decided, Your Worship, in this division in the matter of Mlungisi Mbonani. It's an appeal matter versus the state. The case number is A310 of 2025, where Justice Munzelele stated in paragraph 22 of that judgment that where the offences which the appellant is charged are undoubtedly serious, it is well established that the seriousness of the offence and the strength of the state's case standing alone do not justify the refusal of the bail. The state did not adduce evidence demonstrating that the release of the appellant will undermine the public order or proper functioning of the criminal justice system as envisaged in Section 60, subsection 4E of the CPA. I close the quote. Your Worship, this issue that if he is found guilty, he will go to prison for a long time, and the strength of the state case as it appears on paper, Your Worship, which has not been tested, does not justify this court in refusing the release of Mr. Nkosi on bail. But what Section 64B states, Your Worship, is that if Mr. Nkosi, if he's released on bail, he will evade his trial, Your Worship, then this court should not release him on bail. But there is no evidence that has been put forward by the state that if he is released on bail, he will evade his trial. He is staying within this court's jurisdiction. He has got a property within this court's jurisdiction, and he is married with a woman that works within this court's jurisdiction, Your Worship. And he has a child that resides with this area of jurisdiction, Your Worship. And he will not benefit anything by evading his trial, Your Worship, because his life and family ties are within this court jurisdiction where he is going to be tried, Your Worship. And this argument that appears at paragraph 16.2 at page 22, Your Worship, is not merited and is not supported by any evidence or facts to justify the denial of Mr. Nkosi to be released on bail. They also rely, Your Worship, at paragraph 16.3 that he will influence the witnesses or the evidence. And they say that because he knows the identity of the witnesses and because these are dockets that were found in his house, Your Worship. I don't want to repeat this all again and sound like a broken record, Your Worship. But as I've indicated, is that these dockets that I'm talking about, they are in the police custody. Mr. Nkosi is suspended from his employment and he does not have access to any police information. And this allegation that they are making in this paragraph 6.3, Your Worship, is not supported by any evidence. And in paragraph 16.4, they say that if he is released on bail, he will tamper with police systems or exhibits. How will a suspended police officer be able to enter the offices of LCRC? How will the suspended police officer who does not have access interfere or tamper with the police systems or exhibits? Mr. Nkosi has become famous in the past few months, Your Worship. There is no way that he will enter any systems of the police without anyone recognizing him, Your Worship. And this notion that he will tamper or influence the police systems is not supported by any evidence. And Your Worship, when you are dealing with this issue, you have to look that Mr. Nkosi has no history of being released on bail. and after he was released on bail, he tried to influence the witnesses, or he tried to tamper with any of the investigation. And there is no such evidence, Your Worship. And it is my submission that this contention is not supported by any facts, Your Worship. 16.5, Your Worship, they are dealing with the undermining the criminal justice system, Your Worship. What one will argue that if Mr. Nkosi is released on bail, will undermine the criminal justice system or bail system, is if Mr. Nkosi is released today and tomorrow he commits another offense. And in this case, as I've indicated, there is no evidence that Mr. Nkosi in the past had undermined the criminal justice system or the bail system, Your Worship. As I've indicated, it's his first arrest, and there is no such evidence, Your Worship. But what I can say from this affidavit is that the state just took whatever that is contained in Section 60 and put it in this affidavit in support of this allegation. They are saying that he's associated with individuals that are linked to criminal syndicates, Your Worship. If that is the case, why they are not arresting him for that, Your Worship? He has been in custody for almost 3 weeks. But there is this notion that he is associated with criminal syndicates. But why he is not being charged with that? He is being charged with something very different from what is being alleged in the public, Your Worship. And it is for those reasons that I'm saying that this notion of criminal, his link to criminal syndicates is not linked by any evidence, and he is not before this court based on the charges of the alleged link to the criminal syndicates. And I'm saying this, Your Worship, with due respect, that this paragraph 16.5 was just taken from the CBA, and there is no evidence that has been averred by the state to support this allegation. Paragraph the 16.6, Your Worship, they say that the applicant is the police officer who is entrusted to enforcing the law, and that's the reason why the seriousness of the allocation, including the unlawful possession of firearms. Your Worship, then that will mean, Your Worship, everyone that faces the charges that relate to Schedule 5 bail application should not be released on bail, because all the Schedule 5 bail application relate to the serious charges, Your Worship. But those serious charges are what the state is saying, but they remain to be tested in the trial court, and the presumption of innocence, Your Worship, in bail proceedings always prevails, Your Worship. And the mere fact I've indicated that, Your Worship, last week, that the mere fact that Mr. Ngome, my instructing attorney, is the officer of this court does not mean that he should be treated differently because he's supposed to be the enforcer of the law. That should not be the case, Your Worship. Everyone should be treated equally before the law, and the outrage that they are talking about, Your Worship, are the issues that are happening in another platform that Mr. Nkosi is not charged with, Your Worship. Mr. Nkosi is charged with something that is different to what he appeared or he testified about in Madlanga Commission. And in paragraph 17, they are mentioning this issue of CCTV in his house that was tampered with, Your Worship. And as I've indicated, Your Worship, the evidence is being gathered by the defense as this matter goes along, and the trial court will be in a better situation to decide these allegations, Your Worship. And in this matter, Your Worship, what you are required to consider is whether it is in the interest of justice that he be released on bail. In page 24, Your Worship, paragraph 17.1, 17.2, and 17.4. This issue of whether this safe was mounted or not, Your Worship, the applicant has dealt with it in his affidavit, and the trial court will have to decide that, Your Worship. And even if this court were to be of the view that, having regard to the evidence that is being given to her, that the safe was not mounted, Your Worship, but that is not the reason for refusing bail, Your Worship. However, what we have to consider, the guilty or innocence of him will be determined by the trial court. And in his affidavit, he indicated that he has no knowledge of this stun grenade that was alleged to have been found in his house, Your Worship. And I don't want to repeat what is contained in these paragraphs, Your Worship, because as I've indicated, I have dealt with them somewhere, that the reason why he did not return them because he was on suspension. However, he handed it everything that was in his possession, Your Worship. Your Worship, now I want to take you to this exhibit, the pictures that have been, I think they started at photo number 273 to 274. And if you look at all these pictures, Your Worship, there is no indication in regard to the time when they were taken, and these pictures, Your Worship, will be relevant for the purposes of trial. And picture 271, if I may refer to Your Worship, that safe clearly shows that there's a hole behind that safe. Whether this hole was taken from where it was mounted, this safe was taken from where it was mounted, or it was not mounted, Your Worship, the best court that will decide that is the trial court, where to look at various issues in deciding such evidence as far as the credibility of the witnesses that will be testifying. And also, Your Worship, I know the state will crucify me. I want to withdraw the submission that I've made on Monday, that there's no picture of a grenade. There is a picture of a grenade, Your Worship. However, also this picture of a grenade, Your Worship, that appears in these photos, it does not appear where this photo was taken, Your Worship. But what appears there, it's a green thing. It's picture 612, Your Worship. It's a green thing, and there's a stun grenade on the right and a spray for the police on the right in picture 612. But where was this picture taken? I cannot tell, Your Worship. And as I've indicated, these issues will be the issues that will be dealt with by the trial court, Your Worship. And it is my submission, Your Worship, that Mr. Nkosi has discharged the honors that rest on him, that he be released on bail, Your Worship. I will not read my heads of arguments word by word, Your Worship. However, I think I have driven the point home what this court should consider in the bail application of this nature. However, the one thing that I will state, Your Worship, is that I will quote you, Your Worship, even if I'm not quoting you verbatim. You have said in the past that the bail applications, Your Worship, are not made to punish the applicant, Your Worship. What you look at, Your Worship, is whether if the applicant that is before you is released on bail, he will stand his trial, he will not interfere with the investigation, and he will not undermine the bail system or the criminal justice system, Your Worship. And it is my submission that from the evidence that is before this court, Your Worship, it is clear that Mr. Nkosi will stand his trial, and also he will not interfere with the witnesses, and he does not have any means to go to the police systems and try and influence the investigation or the outcome of the investigation against him. Indicated, Your Worship, that there was a contradiction in the applicant's affidavit in support of this bill, but I've already addressed you, Your Worship, on Monday in this issue in regard to the issue of passport. In one paragraph, he indicates that he has submitted the passport to the authorities. However, in another paragraph indicates that he is willing to submit the passports to the authorities. And on Monday, I was in possession of those passports, and if he is released on bail, and one of the conditions is that he should submit his passport, he is willing to do that. And in far as the issue of passports is concerned, Your Worship, this element before this court only left the Republic of South Africa once in 2012, according to his personal passport, and the one that was issued on his behalf by the state, he never used it, and those passports are available to be made available to the investigating officer. I submit to Your Worship that it is in the interest of justice that Mr. Nkosi be released on bail, unless there's anything that you want me to address on, if Your Worship, and if I may take my instructions if there's something that I left out.
Yes, I have one question,
Yes,
Advocate.
yes, Your
Last week on Monday, when you addressed the court, you indicated that the pictures that were submitted by the state, none of them depicted the stun grenade.
Yes, Your. That's the reason why I'm saying, Your Worship, I'm withdrawing the submission, because after looking thoroughly on these pictures, Your Worship, and being informed by my instructing attorney, I realized that there was a grenade, and that is not it's not a averment that was made under oath in affidavit. In the affidavit, the court will remember the accused is saying that he does not know anything about the hand grenade. And this was a submission that was made from the bar by myself. And as I've indicated, that I withdraw that submission, Your Worship. However, the submission that I can make in respect of that hand grenade, it is not clear where it was taken, Your Worship. That was a submission that was made from the bar. It's not the evidence, Your Worship. However, the submission that was made from the bar, which I withdraw it before I stood down, Your Worship.
Was it a mistake on your part?
It was a mistake on my part, Your Worship.
Thank you.
If I may just check, Your Worship, if there's nothing that I've left out.
Yes.
As a copy, Your Worship, I have no further first submission.
Thank you. Yes, Ms. Kosana.
Ummeleli wakho uyasho ukuthi ucela inkantolo ikhumbule ukuthi umsebenzi noma isizathu sokuthi umuntu akhulule ngayo ibail akusiyona ukuthi inhloso ukuthi bamjezise loyo muntu, kodwa babhekisise ukuthi kuwukulingiswa yini ukuthi umuntu akhulule ngayo ibail. Uma abashushisi babeka icala oboshele lona bathola ukuthi ufakazi abanawo ukuthi bathole isibhamu ngaphansi kwetrasi yomntwana lana lakhona nesibhamu emotweni, kuyasho ukuthi lezo ziveza impawu zokuthi wena uyingozi emntwaneni nomfazi ohlala naye. Bayasho ukuthi elinye icala oboshele lona ukuthi isafe la ugcina kumele kugcine khona isibhamu beyingekho sebondaneni njengoba beyifanele ibe sebondaneni. Bayasho ukuthi kodwa lezi zinto ezitholakala emzini wakho amaphoyisa agcina azithethe. Lokho kuyakhomba ukuthi kahle kahle awuyona ingozi ebantwini basemphakathini noma ebantwini ohlala nabo, ngoba lezo zinto abazitholile njengey'nkamu nazo iy'nkamu zigcine zithethwe abantu bomthetho. Uma babheka ku-paragraph 9 kuyo i-affidavit, bayasho ukuthi uma babheka i-paragraph 9 ey'ncwadini zomthetho ziyasho ukuthi kubalulekile ukuthi inkululeko yomuntu ibhekwe inkantolo ngaphambi kokuthi banikeze isinqumo noma ngaphambi kokuthi bathi bayamjezisa. Inkantolo ayinelanga ikujezise ngecala oboshele lona noma bathi badinga ibail ngokuthi bafuna ukujezisa ngecala oboshele lona. Kumele babheke iy'ncwadi zomthetho ukuthi kubulungiswa yini ukuthi umuntu akhulule ngayo ibail ngecala thizeni aboshele ngalo. Okwamanje babhekisisa ukuthi umshushiso ufuna ukuhlanganisa nesigameko esenzeke khona noma ubufakazi obenzeke khona kuMandlanga Commission, babuhlanganise namacala oboshele wona namhlanje. Yizo izizathu ezenza ukuthi bakunqabele yona ibail. Uyasho ukuthi uma singabheka kwi-affidavit page 19 paragraph 11 lapho iphoyisa eliphethe icala lakho liyasho ukuthi uthola kuphazamiseka ukuthi wena utholakale unamadocket emzini wakho. Uyasho ukuthi uma babuza sona i-station commander siyasho ukuthi yena akazi ukuthi amadocket agcine njani ukuthi abe sendlini yakho. Uyasho futhi ukuthi akakhumbuli ewasayinele lawo madocket. Kodwa ummeleli wakho uyasho ukuthi yena uma bhekisisa lokho bufakazi asikho i-statement esenziwe esifakazela ukuthi akhona yini amadocket ake adolothiwa e-police station thizeni. Uyasho futhi umshushiso ukuthi wena uhambe waya e-police station engaseMosina wacela lawo madocket ukuthi abe ngaphansi kwakho ngoba uzosebenza ngawo lawo madocket. Uyasho futhi ukuthi uma singabhekisisa ukuthi lawo madocket umongameli uyena ocelile ukuthi agcinwe ngaphansi kuka-National Commissioner, njengoba lawo madocket abandakanya amacala ahambelana nayo i-cash in transit namanye amacala asesigabeni esiphezulu. Ucela ukukhumbuza ukuthi inkantolo ibhekisisa ubufakazi obubeke phambi kwakho, hhayi amahemkhemi akhulunywe emhlabeni. Ucela inkantolo ibhekisise kwikhasi lesi-26 lapho bathi wena uma ngokhulula ngayo ibail kungayenzeka ukuthi wena uthusele bona ubufakazi njengoba ubazi ukuthi bobani futhi umoshele ubufakazi obuvekile phambi kwenkantolo. Kodwa lokhu kuyasho ukuthi uyasho phambi kwenkantolo ukuthi akukho ubufakazi obuvezile ukuthi wena sukela ilanga obusho ngalo kufikela namhlanje awukaze wathi ulinga ukumosha nobufakazi obukhona phambi kwenkantolo, futhi awunayo imininingwane ebhaliwe noma imininingwane ekhona ngaphakathi kwamadocket atholakele, njengoba abantu besiphoyisa noma abantu bomthetho bakwazile ukwathatha wonke lawo madocket sukela ilanga osuspendwe ngalo noma ilanga omiswe ngalo emsebenzini ngomhlaka 28 March. Inkantolo kumele ibhekisise ukuthi awukaze wathi ulinga ukuhluphana nabo ubufakazi ababutholile. Uma ibhekisisa i-National Task Team ibona abamele balethe ubufakazi phambi kwenkantolo ukuthi ngeqiniso i-safe bayithole ingekho sebondaneni noma zona ibhango bazithole ngeqiniso emzini wakho, kodwa leyo yindaba bazoyihlaziya kabanzi uma icala lakho liqhubeka liya etrayalini. Uma babheka ku-paragraph 12.1 ne-paragraph 12.2 kuyo i-affidavit bayasho ukuthi kahle kahle wena babandakanisa noma bahlanganisa nazo igebengu ezenza amacala angathi asezingeni eliphezulu njengama-cash in transit namanye amacala. Ngalokho bayasho ukuthi yiso isizathu bakunqabela ibheli. Elinye icala okusho lona ukuthi wena uhlulekile ukufaka yona i-safe ebondaneni njengomthetho uyasho ukuthi i-safe kumele ihlale ebondaneni, kodwa wena uhlulekile ukwenza lokho. Wahlulela futhi ukugcina ibhangu ngendlela efanele ngaphakathi kwayo i-safe. Kodwa amacala okusho lona awahambelani nalokho kwashiwo eMadlanga Commission ukuthi wena usebenzisana nabantu abahambisa zona idakamizwa. Icala okusho lona namhlanje alihambisani nala macala abawasho khona eMadlanga Commission. Futhi akazwisisi ukuthi kungani bafuna ukuhlanganisa izinto ezimbili ezingafani. Ucela inkantolo ibhekisise i-paragraph 13.1 lapho wena wafaka isicelo sokuthi ucela ubufakazi bakho bufihliwe futhi ungaziwa nobufakazi bakho bungaziwa ebantwini bamabhanda, njengoba ushilo ukuthi impilo yakho izoba sengcupheni uma ungaziwa ukuthi wena uthule lo bufakazi khona eMadlanga Commission. Kodwa uma babheka incwadi zomthetho ku-section 64A to E kuyasho ukuthi abukho ubufakazi noma ayikho into engavimbela umuntu ukuthi akhululwe ngayo ibheli nanoma shilo ukuthi impilo yakhe isengozini. Waqhubeka futhi washo ukuthi emva kokuthi ulethe ubufakazi khona eMadlanga Commission wena ukhulekile ngempilo yakho, wayenza yonke into uyenza mihla namalanga futhi wahlala kwakho, ayikho into engathi ibeke impilo yakho engcupheni. Awuzwisisi ukuthi kungani bathi ungakhululwa ngayo ibheli ngoba impilo yakho izoba sengcupheni. Lokho ubufakazi obunjalo abukho. Umeleli wakho uyasho ukuthi ucela inkantolo ibhekisise le-paragraph 21, 14.1 to 14.2 kuyi-affidavit lapho baveza khona ubudedengu ehlangothini lakho nokubeka umndeni wakho engcupheni ngokubeka inhlavu nazo imbangu ezitholakala emzini wakho ubudedengu. Uyasho ukuthi wena insolo ezinjalo uyaziphikisa. Ku-paragraph 15.1 until 15.2 kulapho bechaza khona isizathu sokuthi kungani banqabelana nesicelo sakho sebheli. Bayasho ukuthi wena utholakale ngey'nhlamvu ezingasisemthethweni ongamelanga ube nazo zona inhlamvu lezi noma onganikezanga ilayisensi yokuthi ube nazo lezi nhlamvu. Bayasho futhi ngesikhathi becela yona ilayisensi uhlulekile ukuyiveza leyo layisensi. Bayasho futhi ukuthi wena emsebenzini umiswe ngomhla ka-28 March 2026 emva kwamalanga amane noma amalanga awu-4 wase kwaba kubosha kwabo. Uma babheka ukuthi u-exhibit B TM2 istatement esenze uRosi uyasho ukuthi yebo kuney'mpahla ayitholile kuwena ezasemsebenzini, futhi uyasho ukuthi ngesikhathi bezithatha lezo zinto uma umisa emsebenzini bathathela nayo i-access card. Kodwa ku-affidavit kwashiwo wena njengokushilo ku-affidavit ukuthi ngesikhathi umise ngaso wanikezwa imiyalo ukuthi awumelanga ulibhade khona e-ofisini njengoba umisiwe emsebenzini, batshele nokuthi ubuyise zonke lezi zinto abakunikeza zona ngesikhathi uqala ukusebenza khona. Kodwa izinto besikhona ekhaya noma ezibesisele ekhaya uhlulekile ukuzibuyisa e-ofisini njengoba unikeze imithetho yokuthi awumelanga ulibhade khona e-ofisini, okuyizona inhlamvu nawo ama-docket osebenza ngawo. Umeleli wakho uyaqhubeka kuzinkantolo ukuthi kanti inkantolo uma umuntu angamiswa emsebenzini ngomsombuluko futhi aboshwe ngoLwesihlanu, loyo muntu atholakala nezinto ezasemsebenzini, uyaboshwa yini noma uyasolwa ngokuthi uzijontshile lezo zinto na? Uyasho ukuthi njengoba wena utholakale ngawo ama-docket awutholanga isikhathi sokuthi wabuyise emsebenzini, kodwa i-court ezabe ibhekana ne-trial yakho iyona ezoyihlaziya kabanzi le ndaba enjengaleyo. Ucela inkantolo ibhekisise ukuthi uyaqala wena ukwenza umthetho njengalo futhi ukwazile ukuchaza kabanzi ngokwezempilo yakho. Uma babheka ku-paragraph 6.1 babhekisisa ukuthi wena uyabandakanyeka namacala enzekile futhi wena uwumuntu ovikela izigebengu uma benza amacala angasezingeni eliphezulu futhi uyasho kodwa wena uchazile ukuthi kungani bunawo lamadokhumenti kuwe ngoba bowusebenza nabo. Abukho ubufakazi obuveza ukuthi wena ungaba yingozi emphakathini kodwa umshushisi uvezile ukuthi utholakale ngemali engango-385,000 nemali etholakala endlini ewu-52,000 rand. Lokho akusho ukuthi njengoba imali itholakala kuwe akusho ukuthi uzoqhubeka wenze amanye amacala. Abukho ubufakazi obuvezayo ukuthi sukela ilanga noma unyaka ocashe ngawo uwona 2008 abukho ubufakazi obuvezayo ukuthi uke wenza yini amanye amacala. Kodwa abantu bomthetho ibona abazovezayo ukuthi leyo mali noma leso sambulo semali sitholakele yini emzini. Uma babheka paragraph 16.2 babheka futhi nobufakazi obulethe uyena umshushisi uyasho futhi ukuthi isigwebo noma ubude besigwebo inkantolo ezikunikeza sona akusho ukuthi loyo muntu uzohluleka ukuma eshayini yakhe noma uzoqhubeka ukuze inkantolo efikele abashayeli eshayini yakho. Kumele babheke ubukhulu becala obushele lona nokuthi ubulungisa buyenzeka yini futhi awuvimbelekanga ukuthi uthole yona ibheki. Futhi uma abheka indaba yokuthi uma inkantolo ingakuthola ukuthi unecala futhi ungaya ejele isikhathi eside uyithola ingazwakali ngoba ubufakazi obuveza lokho abukho futhi indaba enjengaleyo ayibambile. Abukho ubufakazi obuvezayo ukuthi wena uma ngakhulula ngayo ibheki uzolibalekela icala lakho ngoba ubhekisisa ukuthi wena uhlala khona ngapha endaweni yasenkantolo yethu futhi nomfazi wakho uhlala ngapha nomntwana ufunda ngapha futhi uhlala ngapha. Ukusho ukuthi nawe uzoqhubeka uhlale ngapha ngoba bomndeni wakho bahlala khona ngapha. Ayikho into engakwenza ukuthi usuke noma ubalekele icala lakho. Uma babheka ku-paragraph 16.3 abukho ubufakazi obuzoveza ukuthi wena uzimisele yini ukuthi uthisele abafakazi noma umoshana nobufakazi obutholakale umshushisi noma iphoyisa ecaleni lakho futhi awunalo ulwazi lokuthi uqubethweni ngaphakathi kwedokhumenti okushelelwe. Ku-paragraph 16.4 abukho ubufakazi obuvezayo ukuthi wena uzimisele ukumoshana nabo ubufakazi noma ama-exhibit atholwe abantu bomthetho futhi uyazibuza ukuthi iphoyisa elimiswe emsebenzini uzokwazi njani ukungena emahhovisini emoshane nobufakazi ngoba wena umuntu osaziwayo noma umuntu odumile kulamalanga. Akwenzeki ukuthi ungangena ofisini ungabi nomuntu okwazi ukubona. Uyasho ukuthi wena awunayo history evezayo ukuthi ungabalekela icala lakho futhi uyacala ukuboshwa. Ucela inkantolo ibhekisise ukuthi ibhekisise ukuthi kahle kahle umshushisi usebenzisa i-section 60 njengoba ibhaliwe encwadini zomthetho ukuthi ucela ukuthi inkantolo ibhekisise ukuthi umshushisi usebenzisa i-section 60 uma ethi wena usebenzisana nabantu abayenza amacala asezingeni eliphezulu futhi usebenzisana nabo. Uyazibuza ukuthi kungani ungaboshelanga lawo macala noma icala elinjengalelo futhi kungani behlanganisa icala abakhuluma ngalo ukuthi wena usebenza nabantu abasezingeni eliphezulu kungani bangakuhlanganisanga nalo icala lelo. Uma babheka incwadi zomthetho ezivela ngaphansi kuka-schedule 5 lapho kumele uveze khona noma kumsebenzi wakho uveze khona ukuthi inkantolo kumele ikhulule ngayo ibheki. Uyasho ukuthi wena icala okushelwe lona icala elikhulu kakhulu kodwa inkantolo kumele isebenzise ilungelo lakho ukuthi bangakuboni kunecala fikela la isikhathi sifika khona ukuthi inkantolo ithathe isinqumo sokuthi ngeqiniso unecala. Bayasho ukuthi bangazami ukuhlukanisa namanye amacala noma bangazami ukuphatha ngendlela ehlukile nabanye abantu njengoba wena umuntu osebenza ngomthetho. uyasho futhi ukuthi icala oshone lona alihambelani nobufakazi noma namacala ashiwo khona eMadlanga Commission. Uma babheka ku-paragraph 70, lapho bakhuluma khona nge-CCTV engaphakathi emzini wakho, la usho khona ukuthi ukhona kuphazamiseka ukube khona kuma-CCTV footage okwenzeka abantu bomthetho noma besiphoyisa ngesikhathi beza kwakho. Uyasho ukuthi bakwazile ukuqoqa bonke lobo bufakazi, kodwa indaba enjengaleyo izodikidwa khona enkantolo ye-trial. Kwi-affidavit ushilo ukuthi awunalo ulwazi lama-stand grenade abakhuluma ngawo ukuthi atholakele emzini wakho, kodwa ucela ukulungisa lephutha alenzile ukuthi kuze ithombe noma ifanekiso abanikeza zona ayikho stand grenade. Uyasho ukuthi wenze iphutha itholakele ethombeni abanikeza zona. Ku-exhibit B, ithombe kusukela ukhasi number 273 fikela ku-274, uyasho ukuthi asikho isikhathi noma ababezama ukuthi lezo ithombe zithethwe isikhathi bani. Uyasho ukuthi lezo ithombe zizosebenzisa enkantolo ye-trial yakho. Page 271 uveza ngathi umgodi ogutshiwe khona emva kwe-safe, kodwa akaziwa ukuthi leyo safe ithethwe kuwo lo mgodi ogutshiwe noma ithethwe kuphi, kodwa inkantolo ye-trial iyona ezothatha isinqumo ngalokho. Uyasho ukuthi kwikhasi number 612 noma 612 ukhona into thizeni engathi ihlaza, futhi kukhona ne-stand grenade engasisandleni samokudla noma ngaku-right, kodwa akasho akuzwisiseki ukuthi leso sithombe sithethwe kuphi. Uyasho ukuthi ucela inkantolo yenze ubulungiswa ikhulule ngayo i-bail ngoba awuzivezi impawu zokuthi wena ungaba yingozi emphakathini noma ungaba yingozi ebantwini ohlala nabo. Uyakhumbuza inkantolo ukuthi inkantolo ingasebenzisi isicelo sakho njengendlela yokujezisa, kodwa kumele bayibhekisise noma ikhumbuze ukuthi i-bail kahle kahle iyenzela ukuthi umuntu bakwazi ukubona ukuthi umuntu uzokwazi ukulumela yini icala lakhe, futhi angeke aphazamise nobufakazi. Kodwa kuyacaca ukuthi wena njengoba uqala kwenza icala leli uzolumela icala lakho baze bacede ngalo, futhi awukaziwa uma eNingizimu Afrika kusukela ngonyaka ka-2012, uphume nje kuphela ngonyaka ka-2012, nama-passport wakho asisekhona. Uma iphoyisa eliphethe icala lakho awadinga bazokwazi ukumnikeza.
Thank you, Ms. Kasana. Right, addressed by the state. Are you ready to proceed, Advocate Sekonyan?
Yes, I'm ready to proceed. I'm just requesting a start.
5 minutes, you said.
Yes.
Right, we'll adjourn. I'll give you an extra 5 minutes, so it will be a 10-minute adjournment, starting to count from now. Courageous? Nkosi. Are we back on record? Thank you. On resumption of case number B300 of 2026 in the matter between the state versus Fannie Nkosi. Which has been done earlier on. Right, before I give you a chance, Mr. Panyani, I have the applicant's heads of argument. They will form part of the record as exhibit N.
The court is.
Thank you. Right, you may proceed.
Thank you, Your Worship. Your Worship, the state has prepared heads of arguments in response to the closing arguments by the defense. Your Worship, I'd like to hand in for the court to follow.
Yes, please.
Thank you, Your Worship. I will read my heads of argument and have a short oral response.
Do you favor the defense with the copy?
Yes, Your Worship.
Do you have?
I confirm it.
Thank you. Yes,
Thank
you
you.
may proceed.
Thank you, Your Worship. In the Magistrate Court for the Regional Division of Tshwane held at Pretoria North, case number B300 of 2026 in the matter between the state and Nkosi Fannie Ezekiel, the applicant. These are the state's closing arguments. Your Worship, this is a bail application in terms of the provisions of Section 60, subsection 11B of the Criminal Procedure Act 51 of 1977, herein after referred to as the CPA. This matter, it is so because the applicant is facing charges, one of which attracts the minimum sentence, upon which 15 years, sentence of 15 years upon conviction, and therefore results under Schedule 5 of the CPA. It is alleged that the applicant possessed various firearms and ammunition as outlined in the affidavit of the investigating officer in contravention of the Firearms Control Act 60 of 2000, herein after referred to as the Firearms Control Act. It is further alleged that the applicant was found in possession of an explosive, which is a contravention of the Explosives Act number 26 of 1956, herein after referred to as the Explosives Act. Furthermore, the applicant is facing charges of obstructing or defeating the course of justice, in that it is alleged that he was found in possession of various police dockets and evidence of cases involving serious and violent crimes in circumstances where he was not supposed to be in possession of such. The applicant is further charged with various counts of theft, in that he is alleged to have stolen state property consisting of dockets and leg irons used in the transportation of detainees. The applicant is also facing charges of money laundering as envisaged in Section 6 of the Prevention of Organized Crime Act 121 of 1998, hereinafter referred to as POCA, it being alleged that he possessed the proceeds of crime. The charges arise from an execution of a search and seizure warrant at the premises of the applicant, which uncovered the evidence of the offenses referred to above. The search and seizure operation was premised on a warrant which was lawfully authorized by a court. The onus rests on the applicant to satisfy the court that the interest of justice permit his release in terms of Section 60, subsection 11B of the Criminal Procedure Act. The state opposes bail on the basis that there is a likelihood that the applicant, if released, will, 1, endanger the safety of the public or any particular person or commit a Schedule 1 offense, 2, evade or attempt to evade trial, 3, attempt to influence or intimidate witnesses or to conceal or destroy evidence. 4, undermine or jeopardize the objectives of the proper functioning of the criminal justice system, including the bail system. 5, disturb the public order or undermine the public peace or security. The basis or the grounds relied upon in justifying the court to refuse to grant bail to the applicant are provided in Section 60, subsection 4A to E, read in conjunction with subsection 6 of the CPA. In his affidavit, the investigating officer expanded and explained the facts upon which the state relies on for opposition of bail. It is submitted that proof of one of the grounds relied upon by the state to oppose bail is sufficient for this honorable court to deny the applicant bail. The state need not prove all the grounds relied upon. The applicant has failed to meaningfully rebut or contradict this evidence and instead relies on bare denial. In particular, the applicant disputes the existence of a stun grenade. This version is contradicted by the investigating officer's affidavit, which expressly records the possession of a stun grenade on page 2, paragraph 4.1, and further confirms recovery during the search and seizure operation, page 10, paragraph 6.11. This contradiction is further compounded by the applicant's oral submission, wherein it was contended that no stun grenade appears in the photographic evidence before the court. This contention is directly contradicted by the photographs forming part of the photo album, in particular photo 612-612, which clearly depicts the presence of a stun grenade among the recovered items. The forensic expert will provide the metadata of the pictures taken from the scene depicting date and time of capture at trial stage. This is not a matter of interpretation, but a direct contradiction of objective evidence, which further undermines the credibility of the applicant's version. It is respectfully submitted that bail applications are by their nature sui generis, and the rigid rules of evidence are relaxed. It is on this basis that our courts admit, during bail applications, hearsay evidence. In the matter of State versus Dlamini, 1997, Volume 1, SACR, paragraph 54, the Constitutional Court held in paragraph 49 as follows in respect of bail. It remains a unique interlocutory proceeding where the rules of formal proof can be relaxed and where the court is obliged to take initiative if the parties are silent, and the court still has to be proactive in establishing the relevant factors. The legal framework. Section 60, subsection 4 of the Criminal Procedure Act provides the interests of justice do not permit the release from detention of an accused when one or more of the following grounds are established. Where there is a likelihood that the accused, if he or she were released on bail, will endanger the safety of the public or any particular person or will commit a Schedule I offense, or where there is a likelihood that the accused, if he or she were released on bail, will attempt to evade his or her trial, where there is a likelihood that the accused, if he or she were released on bail, will attempt to influence or intimidate witnesses or to conceal or destroy evidence. Where there is a likelihood that the accused, if he or she were released on bail, will undermine or jeopardize the objectives of the proper functioning of the criminal justice system, including the bail system. Where in exceptional circumstances there is a likelihood that the release of the accused will disturb the public order and undermine the public peace or security. In the State versus Yanta, 2000, Volume 1, SACR, at paragraph 237, Judge Van Zyl quoted with approval the unreported judgment in State versus Rosani and others, case number A52 of 1999, that in bail applications, the court is not called to weigh proven facts, but to speculate on what could happen in future. The learned judge went on to state that the court may take into account whatever information is placed before it in order to form what it is essentially an opinion or value judgment of what an uncertain future holds. He ended by saying that the court must prognosticate. The Constitutional Court held in State v. Dlamini, State v. Dladla and others, State v. Joubert, State v. Skitekat, 1999, Volume 4, SA, paragraph 623, Constitutional Court, that subsection 60, section 60, subsection 5 to 9 of the CPA lists factors which a court is mandated to pay regard to ground a conclusion whether or not bail should be refused. It was said that if the court find one or more of the factors listed in section 60, subsection 4(a)(d) to have been established, a finding that continued detention is in the interest of justice will be justified. It was further stated in State v. Dladla and others, State v. Joubert, State v. Skitekat above, that a court is not enjoined to accord decisive weight to one or other or all the personal factors mentioned in subsection 9. Whether and to what extent any one or more of such pros or cons are found to exist, and what weight each should be afforded, is left to the good judgment of the presiding judicial officer. The likelihood of reoffending if the accused are released on bail must be assessed in the context of the facts of each case. State versus DV and others, 2012, Volume 2, SACR at paragraph 492, Gauteng North case, Pretoria. It was also held in State versus Thornhill, 1998, Volume 1, SACR at paragraph 177 at page 182, that the statement by the applicant that she or he will not abscond is not decisive. The reliability of such statement must be assessed in the light of other established facts. In State versus Diale and another, 2013, Volume 2, SACR, paragraph 85, it was held that a court must make a finding on probabilities. It was said in State versus Dlamini, State versus Dladla and other, State versus Joubert, and State versus Skitekat, Supra, that there is a fundamental difference between the objective of bail proceeding and that of the trial. The Apex Court stated that in a bail application, the inquiry is not really concerned with the question of guilt. That is the task of the trial court. The court hearing the bail application is concerned with the question of possible guilt only to the extent that it may bear on where interests of justice lie in regard to bail. The focus at the bail stage is to decide whether the interests of justice permit the release of the accused pending trial, and that entails, in the main, protecting the investigation and prosecution of the case against hindrance. The likelihood that the applicant will commit a Schedule I offense. In determining whether this will occur, the court is enjoined to consider, amongst other, the applicant's disposition to do so, as is evident from his past conduct or any other factor which, in the opinion of the court, should be taken into account. The applicant's premises was searched by a team from KwaZulu-Natal in October 2025, and an amount of 385,000 rands was found. The applicant failed to provide a reasonable explanation for it, and it was confiscated and booked into the SAP 13 register. A few months later, the applicant was found in possession of another large sum of money. Some of the offenses he is charged with e.g. defeating or obstructing the course of justice, were carefully planned, executed, and persisted for a prolonged period, it is respectfully submitted that this is indication that the applicant has the propensity to commit Schedule 1 offenses. He has shown to have disregard for the rule of law. This conduct demonstrates a pattern of deliberate and unlawful behavior and indicates a propensity to commit further offenses. The likelihood that the applicant will attempt to evade his trial. The factors to be taken into account in arriving at a decision whether the applicant will attempt to evade his trial include the extent to which the accused can afford to forfeit the amount of bail which may be set, whether the extradition of the accused could readily be effected should he flee, the nature and gravity of the charge, the strength of the state case, the incentive to do so, and the gravity of the punishment which is likely to be imposed should he be convicted on the charges against him. In the instant case, the applicant has been suspended from service. There exists a real likelihood that his employment might be terminated following a due process of disciplinary proceedings against him. It is respectfully submitted that the offenses the applicant is facing cannot be said to be trivial. They are so grievous that he will not evade a custodial sentence should he be convicted at the conclusion of his trial. The evidence against him is overwhelming. He is linked to the offenses by real and objective evidence found at his premises. It is submitted that this provides an incentive for the applicant to skip bail and evade his trial. The applicant is further linked to the offenses by objective evidence recovered at his premises, which strengthens the state case on a prima facie basis. It is tried that the charge of contravening the provisions of the Explosives Act that the applicant is facing carry with them a punishment of a term of imprisonment for no less than 15 years upon conviction. He is faced with that prospect. What is to be expected in prison is a far cry from the life of abundance that he is accustomed to. It is submitted that this on its own is an incentive or motivation to evade trial at any cost. A conclusion that the applicant might evade his trial is difficult to exclude. The seriousness of the offenses and the strength of the state's case also create a strong incentive to evade trial. It is further submitted that even if this honorable court were to impose a high amount of bail, it will be paid using the proceeds of crime, which the applicant can easily forfeit in return for his freedom. The evidence suggests that the applicant has lived a life of a delinquent, notwithstanding the fact that he is a member of the police. For this reason, there is a likelihood that the accused might opt to live a life of a fugitive to avoid possible imprisonment at the conclusion of his trial. It is submitted that for these reasons, the applicant is a real flight risk and should not be released on bail. It cannot be said that there is no risk for him absconding. The likelihood that the applicant will attempt to influence or intimidate witnesses or destroy evidence. The applicant was found in possession of police dockets involving serious and violent crimes, including irrefutable objective evidence which directly implicates the suspects to the commission of serious crimes of cash in transit heists. These dockets were not allocated to the applicant, and no legitimate reason exists for him to be in possession of same. The investigations in those dockets had stalled and as a result were closed. It is submitted that the only reason for the applicant to be in possession of the same was to destroy crucial evidence linking suspects to the commission of serious offenses. The applicant's possession of police dockets, which he was not authorized to have, demonstrates both the ability and willingness to interfere with investigations and evidence. This creates a real risk that, if released, he will attempt to conceal, manipulate, or destroy evidence. The applicant alleges that he does not know any of the state witnesses other than those who conducted the search and seizure at his residence. However, this contention is incorrect in that he was found in possession of police dockets with particulars of victims and witnesses. The likelihood that the applicant will undermine or jeopardize the objectives or proper functioning of the criminal justice system. There is publicly available evidence which indicates that the applicant is associated with both dangerous suspects and very senior police officers. The allegations of capture of the police by criminal syndicates led to the state president establishing a judicial commission of inquiry headed by former acting Deputy Chief Justice Madlanga. The evidence presented at the Madlanga Commission demonstrates that the applicant is at the center of these allegations, working for both alleged criminal syndicates and the senior police officers. The evidence suggests that the applicant operated outside the bounds of lawful police conduct and engaged in unauthorized investigative activities, thereby undermining established procedures. His release would create a real risk of further interference with ongoing investigations. As a result of his alleged involvement in criminal activities, the applicant has mastered the art of undermining or jeopardizing the proper functioning of the criminal justice system. The evidence of the investigating officer in the present case suggests that the applicant acted beyond the remit of his powers by conducting investigations which he was not authorized to carry out, thus breaching police procedures. If released on bail, there exists a likelihood that he will undermine or jeopardize the functioning of the criminal justice system. The likelihood that he might endanger public safety. Instead of protecting the society as is sworn to do as a police officer, the applicant chose to betray his constitutional duties and protected violent criminals by shielding them from investigations. His release on bail will endanger public safety. His conduct demonstrates a disregard for the rule of law and a willingness to protect criminal elements. The nature of the offenses, viewed together with the applicant's position as a police officer and his access to sensitive information, points to conduct that is not isolated but indicative of serious organized wrongdoing. This elevates the matter beyond that of an ordinary Schedule 5 application and calls for a stricter approach. The applicant suggests that his safety is at risk and seeks release on this basis. This contention is misplaced. On his own version, the alleged threats indicate that he is safer within the controlled environment of custody than he would be outside. His release may in fact expose him and others to harm. This argument therefore does not advance his case, but rather undermines the contention that the interests of justice permit his release. In the end, the court must be satisfied that the interests of justice permit his release on bail. It is submitted that the applicant has failed to discharge the onus resting on him to satisfy this honorable court in this regard. It is submitted that it would be contrary to the interest of justice to release him on bail. The applicant's incarceration will not deprive him earning a living in that he is suspended from the police service. His family will not be detrimentally affected. It is respectfully submitted that the applicant is not a suitable candidate to be admitted to bail and bail should be refused. Your Worship, the defense has argued today that in fact, the stance is not clear with regard to the stun grenade. At first, there was no stun grenade. It was not on the pictures. It's a mistake. It's there on the pictures, but there's no really a clear stance as to whether the accused is denying, or the applicant is denying, that a stun grenade was found at his premises. But the court can infer from what he's saying that he is saying that somebody planted that stun grenade, because he's even saying that the cameras were tampered with. However, he, in his affidavit, did, and the investigating officer also testified that or through his affidavit, that the applicant was with the police when they were conducting a search. And at no stage does he allege that they locked him in another room or in the basement, to the effect that they could have planted the stun grenade without him seeing. Furthermore, the applicant does not tell the court how the tampering was done. Safe to say that this matter will be dealt with during the trial. But it is important for this court, in arriving at a just decision, to know why he says that there was tampering with the cameras. Your Worship, furthermore, the pictures that have been handed into the court clearly depict that the safe was not mounted. It was loose, it was not mounted. This is evidence which we can see. The applicant in this matter, all he wants to do is just deny, deny, deny. He does not admit anything, but he wants this court to release him on bail, but he does not want to take the court into his confidence with regard to important matters. And as has already been indicated in my head of argument, Your Worship, that the issue of the time, it is well known that when LCRC takes photos, there's an accompanying affidavit. The affidavit is in the docket. The state just handed in relevant pictures of items which were recovered. However, during the trial, the state will call the members of LCRC who were present when taking the pictures. Furthermore, the investigating officer did make mention that during the search, at a point, the representative of the applicant arrived, and nowhere is it mentioned that there was any tampering with the cameras. Your Worship, it is true indeed that bail is not a punitive. However, the inquiry that this court must make is whether the interest of justice permit the release based on the risks identified in Section 60. The submission that the applicant will stand trial and comply with conditions is not sufficient. The court must assess the risk objectively and not on assurances from the applicant. Your Worship, even on the issue of the passport, the applicant's own version was inconsistent. In the affidavit, it was said that his passport was handed over to the investigating officer, and then on the next occasion, it was said that he's willing to hand it over. That inconsistency goes directly to his credibility and his willingness to be candid with the court. Your Worship, it's very easy for the legal representative of the applicant to say, I withdraw that submission. There have been very serious allegations that are made either to the prosecution or into the investigating officer. The prosecutor was not in court. The investigating officer and his team tampered with the cameras, but there's no evidence. It's just baseless accusations which are thrown without any evidence. Your Worship, the applicant also says that this is his first arrest. The state is submitting that the absence of past interference does not eliminate the risk, and that this court must consider the applicant's position as a police officer being suspended or not, based on his knowledge of systems and his access, all of which increase the likelihood of interference, whether it will be direct or indirect. The fact that he has only traveled once, limited travel history, does not eliminate the risk of absconding, particularly in the light of the seriousness of the charges and the strength of the state's case. What remains before this court, Your Worship, is objective evidence, including the investigating officer's affidavit and the exhibits which implicate the applicant. The defense did not bother to neutralize that evidence. They just merely disputed. Your Worship, the defense relies on assurances, inconsistencies, and now even withdrawn submission. The state, on the other hand, relies on evidence, objective evidence. In those circumstances, the state submits that the applicant has failed to discharge the onus, that it is in the interest of justice for him to be released on bail. And finally, Your Worship, the state submits that the defense presented denials before this court and attempts to defer all the issues to the trial court. What is before this court is evidence which implicates the applicant, coupled with a pattern of improbabilities and contradictions. In those circumstances, the risks contemplated in Section 60 remain real, and the state requests that the accused application to be released on bail be dismissed. Your Worship, furthermore, there's a stage at which the accused spoke about the exhibit TM2, and on TM2, it shows that the accused was issued with 60 ammunition, and he returned 72, which means he had 12 more, which is unaccounted. Upon the search and seizure and his arrest, there was 42 more state ammunitions which were found in his premises, which were not accounted as to how he received them. Your Worship, the state would also like to remind the court that the investigating officer's affidavit indicates that there is a statement from the clerk at the archive store where she indicates that the dockets that the accused, especially with that Rietgaard case 671 of 1/2013 of common robbery, the accused is in possession of this docket, but there's no indication when it was booked out. And even in the docket control register, there's no record that it was signed for. Further showing that the accused or applicant works in unscrupulous ways. Your Worship, the state is requesting that the bail be denied. Thank you, Your Worship.
Thank you. Right, can someone please favor Ms. Kosana with a copy of the state's closing argument to make her life a little easier?
Okwamanje umtshutshisi uyasho ukuthi esicelo sakho se-bail uma ngenzeka ukuthi inkantolo ithole unecala ngenzeka ukuthi isihloko sifanele isihloko esingama-50 yesifana nejele bayasho ukuthi futhi siwela ngaphansi kuka-Schedule 5 kulapho uveza khona ukuthi kungani wena kumele ukhulume ngayo i-bail. Bayasho ukuthi ecaleni lakho bathole izinhlamvu kanye nazo ibhangi. Bayasho ukuthi utholakale nazo izinto eziphumayo wona ama-explosives. Bayasho futhi ukuthi wena ukhulume ngabo yomthetho njengoba ukwazi ukutholakala ngawo amadokhumenti eziphumayo. Bayasho ukuthi elinye icala obashele lona icala lokudontsha bayasho ukuthi utholakale ney'nsimbi zokukhosha enyaweni futhi nawo amadokhumenti futhi ubandakanyeka necala lokuphakamisa imali. Emva kokuthi bayasesha wona amagceke wala uhlala khona bayasho ukuthi inkantolo ikwazile ukunikeza incwadi yokuthi noma imvume yokuthi baqhubeke baseshe khona la uhlala khona noma emagcekeni wala uhlala khona. Bayasho ukuthi futhi wona bayaziphikisa isicelo sakho se-bail ngoba kungenzeka ukuthi wena ube yingozi emphakathini futhi ungathusela nabufakazi noma ubambane nabo ubufakazi noma ubalekele icala lakho noma uphazamise ukuthula kwasemphakathini. Bayasho ukuthi kuye i-affidavit ekhiphe uyena ophethe icala lakho noma iphoyisa ephethe icala lakho. Uyasho ukuthi ubufakazi obukhona ubufakazi obunamandla kakhulu futhi wena uhlulekile ukuphikisa lobo bufakazi. Waphikisa futhi ukuthi kutholakale yona i-stand grenade egcekeni langakithi kodwa kunesithombe noma ubufakazi obuvezayo ukuthi itholakele leyo stand grenade njengoba ummeleli wakho ashilo ukuthi wenze iphutha njengoba abonile ethombeni ukuthi itholakele leyo stand grenade. Kodwa uyasho ukuthi kwezobuchwepheshe be-forensics bazoletha ubufakazi nabo nesikhathi badingela ngaso ukuthi lezo yithombe zithethwe nini futhi zithethwe sikhathi bani. Ucela inkantolo ukuthi ibhekisise ukuthi esiceleni sakho se-bail kumele babhekisise ubufakazi obulethwe phambi kwenkantolo bangezwa futhi ngama-template. Uma babheka ku-section 64 incwadi zomthetho kulelo Criminal Procedure Act ebheka ukuthi ngaphambi kokuthi inkantolo yenze ukulingiswa kumele babheke ukuthi loyo muntu akuyona ingozi emphakathini futhi angeke abekele icala lakhe, angeke aphazamise ubufakazi ophambi kwenkantolo futhi aphazamise inkambiso yasenkantolo. Incwadi zomthetho zithi inkantolo kumele ibheke okungenzeka ngakusasa bangabhekisisi ukulingiswa kuphela, babhekisise into wena noma icala ongalenza ngakusasa. Babheka futhi ukuthi uma amaphuzu esicelo lwafunda phezulu uma likhona elilodwa noma amaningi avelayo ngokwezempilo yakho inkantolo kumele ibhekisise noma ihlaziye kabanzi lawo maphuzu ngaphambi kokuthi inkantolo ithathe isinqumo sokuthi ungakhululwa ngayo i-bail noma cha. Okwamanje bayabhekisisa ukuthembeka kwakho ukuthi ngeke ubalekele yini icala oboshelwe lona futhi bahlaziya nabo bonke ubufakazi obuletha phambi kwenkantolo nakho konke okuphikisayo ukuthi utholakele egcekeni lakho. Inkantolo ye-Apex iyasho ukuthi inkantolo ezophatha iy'calo ze-bail akumelanga ibhekisise ukuthi umuntu lelo cala lenzile noma cha, kumele babheke ukuthi loyo muntu angayenza yini lawo macala futhi uma akhululwa ngayo i-bail. Emva kokuthi abantu bomthetho baseshe igceke lapho noma la uhlala khona bayasho ukuthi ngonyaka ka-2025 nyanga ka-October uthola isabhulo semali esingango 382,000 rand futhi ngonyaka olandelayo uma basesha la uhlala khona utholakale enye imali kanye nezinye izinto engasisemthethweni. Lokho kusho ukuthi wena ukhombisa impawu yokungahloniphi umthetho njengoba wenze amacala anjengalawo iminyaka elandelayo. Uma abheka endabeni yokuthi wena uzobalekela yini icala bathola ukuthi wena kahle kahle awulahlekelwa yilutho uma ungakhululwa ngayo i-bail noma ubalekela lona icala ngoba uma inkantolo ingakhululwa ngayo i-bail yona imali ezobe isetshenziswa esikhathini yona i-bail yobe yimali ewuyithole ebugebengini bakho noma imali oyithole uma wenza lobo bugebengu. Bayasho ukuthi inkantolo kumele ibhekisise ubukhulu becala lakho babheke kwezempilo yakho futhi babheke nobufakazi obuze phambi kwenkantolo. Bayasho futhi ukuthi babheke ukuthi ayikho into ongalahlekelwa yona njengoba usubuyisiwe emsebenzini futhi icala lakho icala engathelekisa kakhulu. Ubufakazi obulethwe phambi kwenkantolo ubufakazi ongakuthumela ejele isikhathi eside. Lokho kusho ukuthi wena kungenzeka ukuthi uyicabangisise indaba yokuthi ubalekele icala ngoba uma inkantolo ingakuthola necala bangakuthumela ejele iminyaka engango-15 years noma kuya ngaphezulu. Yiso isizathu esingenza ukuthi wena ubalekele lelo cala. Bayasho futhi ukuthi wena ungaba yingozi emphakathini uma ungakhululwa ngayo i-bail futhi ungaphazamisa nabo ubufakazi njengoba bakwazi ukuthola wona ama-docket la uhlala khona futhi uyabaza suspect noba kusolwa ukuthi akubani kula macala wama-docket buwaphethe futhi bahlulekile ukuphenyisisa kuwo amacala wama-docket buwaphethe kusho ukuthi wena kahle kahle uhlose ukumosha ubufakazi obungaphakathi kwala ma-docket kula macala wonke labo ama-docket buwaphethe. Bayasho ukuthi uphethe nemininingwane yabantu abalahlekelwe noma yabantu ama-victims kulawo macala ama-docket waphethe njengoba bokwazi ukusebenzisana nabakhulu basesiphoyiseni nazo igebengu esisezingeni eliphezulu okusho ukuthi wena ngaphakathi usebenzisana nabo bonke laba bantu abenza amacala njengalawo njengoba ukwazi ukubavikela labo bantu ngokufihla ama-docket wabo. Awusiphathanga njengomuntu osebenza ngomthetho futhi nobufakazi buyaveza ukuthi kahle kahle la macala wama-docket waphethe kungasimacala anikezwe wena ukuthi kube uwena owaphenyisisayo noma owahlaziyo, kodwa ngalokho wena okwenzile ukuthi uvikele labo bantu abenza amacala lawo noma izigebengu ezenza amacala lawo. Bayasho ukuthi wena ufake isicelo sebheyili ubhekisise ukuthi impilo yakho isengozini uma ungaphakathi ejele, kodwa umshushisi uyasho ukuthi kahle kahle wena uphephile uma ungaqhubeka ukuboshwa ngaphakathi ngoba uma ungaphuma la ngaphandle kungenzeka ukuthi impilo yakho isengozini ngoba labo bantu osebenzisana nabo kungaba yibona abazama ukubeka impilo yakho engozini. Inkantolo kumele iyaneliseke ukuthi ukulungiswa biyenzeka ngoba inkantolo kumele ibheke ukuthi iyaneliseka uma baqhubeka bagcina khona ejele ngoba babhekisisa ukuthi wena usasebenza awulahlekelwa ngumsebenzi umisiwe kuphela emsebenzini futhi abamndeni bakho abasisemupheni noma impilo zabo zisisemupheni akubona ukuhlukumezeka kwamalungelo wakho uma ungaqhubeka uhlale esejele, kodwa kuyoba kuyibona ubulungiswa uma ungaqhubeka uhlale esejele. Umshushisi ubheka futhi nendaba yokuthi ummeleli wakho ngaphambilini bekashilo ukuthi awekho ama-stand grenades atholakele kuwena, kodwa namhlanje uyasho ukuthi ucela ukulungisa iphutha elenzekile. Uyasho ukuthi uyawabona ama-stand grenades njengoba avezwa lapha kuma-picture. Akucaci ukuthi yini kahle kahle into eniphikisayo. Into ishoyo ukuthi kukhona umuntu owafakile lawo ama-stand grenades ungabonanga futhi awusho nokuthi i-CCTV noma amakhamera noma angasendlini yakho bawaphazamise kanjani. Inkantolo izokwazi kanjani ubufakazi balokhu uma uhluleka kuchaza ukuthi leyo nto into eyenzeke kanjani. Iy'thombe ezilethe phambi kwenkantolo ziyaveza noma ziyakhomba ukuthi i-safe etholakale endlini beyingekho semondaneni futhi wena into oyenzayo ukuthi ubuke yonke into noma konke ubufakazi obuze phambi kwenkantolo awuvumi lutho, kodwa ufuna inkantolo iphile ngayo ibheki uhluleka kuchaza kabanzi ukuthi izinto zitholakele kanjani. Uma babhekisisa endabeni yesikhathi umshushisi uyasho ukuthi leyo ndaba uzoyishiyela kwabantu be-LCRC ngoba yibona abathatha iy'thombe futhi ngesikhathi bathatha iy'thombe kuyenzeka ukuthi babuye bathathe nazo i-statement, kodwa lokho bazokuhlaziya kabanzi nokuhamba kwesikhathi uma bahlaziya icala lakho ngoba bazobabiza ukuthi nabo balethe ubufakazi basho ukuthi konke lokhu kuthethwe isikhathi bani. Umseshi wecala lakho uyasho ukuthi ummeleli wakho bekakhona ngesikhathi beza kwakho abantu bomthetho bazosesha endlini yakho, kodwa ummeleli wakho akashongo ukuthi amakhamera wasendlini yakho kube khona ukuphazamiseka ukuba khona. Abhekisise futhi ukungathembakali noma ukungazwakali ngasihlangothini likammeleli wakho ukuthi ngaphambilini uthe ama-passport wakho bawanikeze umseshi wecala lakho, kodwa ivikelekile ushilo ukuthi ama-passport asesemabuye futhi uzimisele ukunikeza umseshi ama-passport. Ngiyasho ukuthi umuntu ongacacisi kabanzi ukuthi ume futhi nehlangothi lakhe alizwakali kabanzi ukuthi uthini. Bayasho uyasho futhi ukuthi kube khona inzolo eziningi ehlangothini liwuseshiwe becala lakho futhi nenzolo ezibekwe ngaphezu kukamshushisi ungathi umshushisi naye akathembakali kodwa wena nawe uveze njengomuntu ongathembakali njengoba uhluleke ukusho kabanzi ukuthi lezi zinto ezitholakele noma uphazamiseka kwekhamera into eyenzeke kanjani. Uyasho futhi ukuthi kahle umshushisi usebenza ngobufakazi obuveze phambi kwenkantolo wena uhlule ukuphikisa lo bufakazi ngamaphuzu azwakalayo futhi ucela inkantolo ingakhulumi ngayo abhekisise nendaba yokuthi utholakale izinhlamvu ezingango-42 wena uhlule ukuzisho ukuthi zitholakale kanjani ngakuyo. Lokho kusho i-clerk ephethwe yona indawo yama-inhlamvu. Uyasho ukuthi i-docket ye-case engase-rate hard ikwiqiniso ukuthi beyiphethwe wena kodwa akuveli encwadini zabo ukuthi ukwaze ukuyitholakala isayinele nini futhi ikhishwe nini. Ngalokho ucela inkantolo ingamukeli isicelo sakho sebeyi ngoba uhluleke ukuveza zonke lezi zinto abakhulume ngazo futhi awubonakali njengomuntu othembakalayo ekufakazini bakho.
Thank you, Mr. Sana. Can you give the copy back to Ms. Antonio so that you can give it back to the person? Right, Ms. Antonio, please pass me the question. Right, the case of argument of the state, follow the record. Right, advocate, Rally, wish to reply?
Yes, Your Worship, I will be brief. However, what I want to state for the record, I'm glad that the state has considered that we don't have to prove our guilt or innocence at this stage. And if the state concedes that, Your Worship, then it goes further to, by logic, it says that we do not have to dispute whatever allegations that they are raising, but what you need to do is to put the facts that indicate that it will be in the best interest of justice that the Mr. Nkosi be released on bail. We don't have to bring evidence as such. The court will be well aware that at this stage we are not privy to anything that the state has. So how can we dispute the evidence that they have if we are not privy to what they have? However, Your Worship, there's another issue that I wanted to touch on. If the court can just go to the charge sheet, Your Worship, specifically charge 8. The court will note that according to the charges that we are aware of, he has been charged for that offense that occurred on the 2nd of April 2026. However, if you look at Exhibit B at page 2, the affidavit of the investigating officer, at page 4.9, the investigating officer is referring to the 2 counts of contravening of that section, which is not consistent with what is before this court. Now we are expected to answer to the charges that have not been leveled against the accused, because there's only one count, the account that occurred on the 2nd of April 2026. I'm saying this, Your Worship, to indicate that the state is just billing its case as it goes. And from the onset, before we were aware what the state will say, we disclosed that there was a search and seizure that occurred last year. And Mr. Nkosi was not charged with that. Now the state wants to rely to the search and seizure that occurred last year. that now my client has a propensity to commit Schedule 1 offences. This is not supported by the evidence, and this is not the charge that he has been charged with. Maybe they can charge him at any stage if they want to charge him, but this is not what he's facing before this court. And it is my submission, Your Worship, that I'm not going to repeat what I've said, but I will stand by that, Your Worship. However, there are two issues that I've raised before the state replied, but now the state is going back to those issues, Your Worship. The submission that was made by me in regard to the stun grenade is not a submission that was made by the applicant under oath. It's the address that was made by me, of which if I make a wrong address, Your Worship, at any stage I can withdraw such an address. And this is supported because I have taken the court into confidence and I referred, Your Worship, to the necessary picture, and I indicated that Mr. Nkosi, under oath, he disputes that this was found in his house. And the issues of tampering with cameras, the state rightly points out, Your Worship, that that is a trial court that has to decide that. But what we have to decide is whether it's in the interest of justice that he be released on bail at this stage. And in paragraph 21 of the heads of arguments, Your Worship, the state refers to the allegation of 385,000, which is not, as I've indicated, what Mr. Nkosi is facing in this court, Your Worship. That is not a charge that Mr. Nkosi is facing. And also the issue, Your Worship, that I have ventilated on Monday, that I brought this to your attention, Your Worship, when I started to address you, that there's a contradiction in regard to the whereabouts of the passports. However, even though in the preceding paragraph she said that he handed the passport to the investigating officer, but if you read to the affidavit holistically, because you don't have to look at the evidence before you, Your Worship, in piecemeal approach, you will find that Mr. Nkosi indicates that he is willing to hand over the passports. But now the state wants to make a big issue of these issues that I've indicated, Your Worship. It is my submission that the state, the defense has made out a case that Mr. Nkosi, it will be in the interest of justice that he be released on bail. As a court pleases, Your Worship.
Umeleli wakho uyasho ukuthi njengoba umshushisi ashilo ukuthi yena akadingeki ukuthi alethe ubufakazi noma achaze ukuthi lokho ubufakazi abanakho batholakale kanjani. Uyasho futhi akona umsebenzi wakhe kodwa inkantolo inkantolo isebenzise kwi-charge sheet, charge number 8, lapho kusho khona icala okukhona elenziwe ngomhla ka-2 April 2026, abhekisise ne-exhibit B ku-page number 2 kuyela ku-page 4.9, lapho umseshi wecala lakho esho khona ukuthi ubushole futhi amacala amabili abandakanya nayo i-charge 8. Uyasho ukuthi lelo cala uzolukhumela kanjani njengoba bangakazange ukuchaza ukuthi icala elinjengalo, futhi uyasho ukuthi kahle kahle umshushisi la umuntu ozakhela icala akanabo ubufakazi obuphathekayo njengoba kunokuseshwa okuba khona emzini wakho ngonyaka ka-2025, kodwa bahlulekile ukuthi babophele lezi zinto ezitholakale eceleni lakho ngonyaka ka-2025, kodwa lokho bafuna ukuveza ecaleni lamanje, futhi abanabo ubufakazi obuphathekayo. Lokho akusho ukuthi izinto abazithola ngonyaka ka-2025 kumele kuboshelwe zona kulo nyaka wamanje noma bazifake ecaleni oboshelwe lona manje. Ucela inkantolo ibhekisise amaphuzu amabili avezwe umshushisi. Ucala ngendaba ye-stun grenade. Uyasho ukuthi indaba ye-stun grenade uyena umeleli wakho oyikhulumile ukuthi ayitholakala kuwena, akusukuwe okhulume njalo. Uyasho ukuthi njengoba uyasho ukuthi uyena osho njalo, ukwazile nokuyikhipha indaba noma ukuyilungisa phambi kwenkantolo ukuthi wenze iphutha emva kokuthi abhekisise lawo ma-picture noma lozo yithombe anikezwe zona. Endabeni yamakhamera ukuthi kube khona ukuphazamiseka kwamakhamera, ucela ukuyishiya ezandleni zenkantolo ezebe idikida udaba lwakho noma i-trial yakho. uma abhekisisa ku-paragraph 21 la bathi bathole khona isambulo esingango 385,000 rand, uyasho ukuthi kodwa lokho akusikhona ukusethe enkantolo namhlanje noma akusicala oboshule lona namhlanje. Ucela inkantolo ibhekisise futhi kwi-affidavit, bayifundisise i-affidavit abanikeze yona ukuthi endabeni ye-passport akashongo ukuthi i-passport sebayinikeze umseshi. Bayasho ukuthi bazimisele ukunikeza umseshi i-passport yabo. Bayibhekisise indaba le ukuthi kube nephutha elenzekile ehlangothini la, kodwa i-affidavit iyasho ukuthi bazimisele ukunikeza umseshi i-passport yabo. Ngalokho uyabona ukuthi kuwukulingiswa ukuthi wena ukhulume ngayo inkantolo. Sorry.
The court needs at least 2 days or so just to write a judgment. Within the course of this week, please check when I got the duty advocates opinion. Please check when I got the within the course of this week. The sooner the better.
Your Worship, on my side, tomorrow I'm not available, but on Wednesday I'm available.
Wednesday?
Yes.
Yes,
Wednesday is suitable.
Mr. Antonio, can I please have the court book of this court book? Magistrate, yes, please. Please stand up, Mr. Nkosi. Your formal bail application is going to be finalized in this court, Court B, on the 22nd of April 2026. It is for judgment on the 22nd of April 2026 in this court. Judgment in the formal bail application is handed down. You will be in custody until then.
Cala la petizione inkantolo ngomhlaka 22 April wayakuthi inkantolo ithatha isinqumo esikoleni sakho sephinda okwamanje ungobuyele ngaselethe kuba ngomhlaka 22 April.
Right, for a judge?